case briefs, and so much more. LSData's got what you're looking for.
In an intriguing case that delved into America's efforts to counteract pollution, a legal dispute between the Environmental Protection Agency, EPA, and a number of animal feeding operations, AFOs, came to a head in the United States Court of Appeals for the District of Columbia Circuit in 2007. Tensions arose when the EPA expressed concern over the emission of pollutants from AFOs, a hot topic given the regulations set forth by such as the Clean Air Act, CERCLA, and EPECRA. The catch, however, was they did not have a concrete manner to measure these emissions. Enter the consent agreement, an invitation extended by the EPA for AFOs to collaborate on developing an emission estimation methodology. Taking up the EPA on its offer had its clear benefits. Not only would the EPA hold fire on administrative actions and lawsuits against participating AFOs for a designated period, but they were also willing to deter legal actions related to certain past and ongoing violations of the acts in question. Yet this wasn't a one-sided deal. In return, AFOs were required to pay a civil penalty and fund a nationwide study focused on scrutinizing emissions from their housing structures and manure storage areas. This alliance forged by the consent agreement, however, was challenged in court. Despite this, in a significant move, the court dismissed the petitions for review. Their ruling clarified that it had no power to review the EPA's enforcement discretion. This meant that, by virtue of its statutory authority, the EPA's decision to withhold enforcement action or settle litigation was exempt from judicial review under the Administration's Procedure Act, APA. The underlying message was clear. The EPA held a significant level of control and discretion in pursuing its mandate to safeguard environmental standards.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class